Welcome to the Los Angeles Injury Attorney Podcast for the law offices of David Olan. This podcast is for anyone who has suffered serious personal injuries, or for families who have lost a loved one in a wrongful death because of the carelessness or negligence of another. We will also touch upon information for those who have been the victim of unfair employment practices or who have been wrongfully denied insurance coverage. Your host for this podcast is attorney David Olan. David is a leading Los Angeles trial lawyer. As founder and managing partner of Olan Law, David leads a team of attorneys and support staff who are dedicated to seeking justice. In this episode, Mr. Olan talks about auto, truck, and motorcycle accidents. If you or someone you love has been hurt in a vehicle accident, this episode is for you. David will discuss the many types of common car accident injuries he sees, what you should do immediately following an accident, some of the kinds of compensation that can be awarded in these cases, and much more expert advice for anyone facing or contemplating filing a vehicle accident lawsuit.
So we're talking about auto accidents here, and the fact is that anybody in California, you're mandated to have insurance, and they'll come down real hard on you. They won't register your car if you don't have insurance. You can get fined and ticketed. So in recent years, we've seen that there are more people that have insurance. Not everybody has insurance, so it's always a good idea to have uninsured motorists, which also acts as underinsured motorists, because in California, we have minimum limits for each claim, and then we have combined limits. The minimum in California is $15,000 per incident. It's been $15,000 ever since I can remember, ever since I've been in practice. So I think it's a pretty low limit. And 30 is for one person can only get 15,000 maximum, but if there are like 5 people, they might each get 6,000, or one might get 15, and then the other 4 would split up the $15,000 or something like that. And then after, it's usually 15, 30, 25, 50, 30, 60, 100, 300, 200, 500, then you get into excess. So there should be insurance. If, for example, somebody doesn't have insurance, so they have like a $15,000 case and your case is worth $100,000, if you have uninsured motorists that is greater than their single limit, it will compensate you. Then your carrier, the person who has uninsured motorists, steps in the shoes of the uninsured or underinsured driver, and they can't raise your premiums or exclude you or anything like that. People worry about that. So there's only benefit in getting uninsured motorists, and medical payments are like no fault. Most people should have at least $5,000 in med pay. That's what it's called. And then that's a big benefit too, because they don't question it. They send the money for the bills that you have incurred up until your limit, which is, 1,000, 2,000, 5,000, 10,000, then it can go up to 25 or 100,000. I've seen all kinds of limits. But in California, the basis of an automobile claim is negligence. Negligence is a very simple term. It's you have a duty. You have a duty, for example, to drive safely. If you drive unsafely, you're breaching that duty. That goes for any duty you have, whether you're a homeowner and you have an unsafe dog or an unsafe stairs or something, you breach the duty. If it causes damages, that's what's known as a tort. That's negligence, and then you can hire a lawyer and recover, assuming that the people have insurance, which most people have auto insurance or homeowners insurance, or often people have renters insurance, so that goes for commercial policies too, commercial vehicles, commercial premises, like if you go into Target or Ralph's, they're either insured, or they're big companies are either self-insured or they have self-insured retention, which could be $100,000, could be $1 million, and then they pay into that. Once they have exhausted that, insurance kicks in, and a lot of the bigger companies will do that because their premiums would just be, silly if they were to insure everything. So with most big, they have what's known as self-insured retention, SIR. So basic rules of road apply. Somebody hits you, they rear end you, they're following too close, or they make a left turn in front of you, vehicle code 21801A, or, whatever happens head on, however somebody is responsible, they have to pay the proportionate share of the responsibility. For example, like car accidents can also be the fault of two people. Somebody's making a left turn and, somebody runs a red light, but the person in the left turn hesitated or didn't take, then they can also, California is what's known as a comparative state. It could be 50-50 or whatever share of responsibility. The tort fees of the person that caused their insurance would pay, if the case is worth 100,000, insurance company determines, or through verdict or however, that person's 50% liable, they pay $50,000. And they pay for, there's economic damages, which are, medical bills incurred or will be incurred, or they have lost earnings that you've lost or you will lose in the future, and you're entitled to past and future medical and lost earning. And the buzzwords are reasonable and appropriate. The insurance company say, well, you treated too long and the costs were, so that was unreasonable and the charges were inappropriate. And so that's important, that everything is properly coded and the doctors are credible and you're getting the actual treatment, which is usually, there's treatment, which is chiropractic, physical therapy, massage, it could be acupuncture, it could be, there are a number of modalities of treatment, but then there's evaluation, which is, you get a surgeon, an MD, which you should always have an MD, evaluate you, and they have to give you a prescription for therapy typically. But then the evaluation could be by a neurologist, orthopedic surgeon, an osteopath, a neurosurgeon, and they can evaluate you and they can order tests. X-rays are typically done, MRIs or CAT scans are also done. We can typically refer people to doctors that will work on a lien, meaning they will be paid when the case settles. It's what's the common fund, and then that's usually the best way to do it, because a lot of times insurance doctors or regular, they don't have the incentive to make a legal case out of it, nor do they put what would help for what somebody you're entitled to, what you are out of pocket, economic special damages. And then there's also more of a subjective thing, which is general damages, pain, suffering, upset, inconvenience, which is, again, a hard thing to determine, and oftentimes it's determined most of the time by the objective injury, either the diagnosis, prognosis, amount of medical treatment, what the doctors say, you couldn't play your sports, you couldn't work, you couldn't hang out with your kids, you couldn't sleep at night, you're in pain. There's a value to that, again, subjective. So the basis is typically determined on the objective injury, reports, medical bills, lost earnings, so on and so forth. And that I actually created a pyramid. I can give you that and show it on the podcast of how that's determined. So somebody says, well, I'm injured, but I don't want to go to the doctor. I said, well, the insurance company can't help. They're not going to recognize an injury unless you go to a doctor. I mean, insurance companies are very conventional. Everything has to add up black and white. And even then, sometimes they don't pay. They're not in the business of paying consumers. They're in the business to take in premiums and invest their money and increase their net worth. That's it. And, there are better companies, and then there are, well, they're all, let's assume they're all pretty bad. There are lesser of evils. And, there are some companies that are pretty legit and will take responsibility. More the well-established, the bigger companies typically do that, but then they also have the resources to fight, or things can get, fall between the cracks. One hand isn't tied. So you see it all over the place, but typically you need a lawyer to help you, A, determine your rights, and B, secure them. Some of the more common types of auto accidents we see, usually it's a rear ender, because people just aren't paying attention. They look down and or people stop short. So that's, I would say, at least 50%. A lot of times you'll see red light, green light, or stop sign disputes where you really need witnesses or cameras or admissions or something like that, or left turning cases or lane changes, um, or reckless driving. You'll see drunk driving a lot, which is drunk driving cases are something that they take a little bit more serious because they will pursue the, if you're caught drunk driving, obviously there are criminal implications. Get thrown in jail, you're fined, lose your license, all kinds of things, probation. But insurance still applies, but it only applies to the negligence. We talked about negligence, breach of duty. There's something also called punitive damages, which is when somebody's actions their conduct is despicable or outrageous, unfathomable. There are all kinds of buzzwords for intention is usually punitive damage, which is above and beyond. It's to punish and deter the defendant based on their net worth. So for people that are drunk driving, the intent is inferred. If you jump into a car knowing that you're drunk, malice or intent, which are required for punitive damage, are inferred under a case called Taylor versus Superior Court. If you get punitive damages, the insurance company in any case doesn't have to pay for them. So that's always a club. And it's more likely for the insurance company to settle because the insurance company's duty is to protect their insured. That's their duty. They don't want to exceed policy limits. They want to pay within policy limits. So if your case is, if you have a $15,000 case or you have a $10,000 case and the 15 policy, they may just pay the 15 because they don't want the risk of going over their policy. And there are very few things now insurance companies are scared of, but they don't want punitive damages. They don't want to go over policy limits. And they just don't want an adverse verdict. But insurance companies don't really aren't motivated until they feel fear, or just a sense of duty, which some do, some don't. But usually a policy limits is one of the vulnerable. If they have a small policy, they should tender it because they don't want to go excess. And if you demand the policy and it's reasonable, they don't pay it, then the insurance company can be on the hook for a total. Let's say somebody has a $15,000 verdict policy, and the insurance company, you send them enough medical or proof of it, liability, so it's reasonable, and the carrier doesn't pay, which sometimes they don't. It falls through the cracks, so they don't know what they're doing, or they're trying to be smarter than you are, and then they don't pay. And then they can offer to you later and say, hey, sorry, you had an opportunity. You're not accepting. We're going to go to verdict. You then go to verdict. The insurance company is responsible for any excess verdict that, came out from 1958 was the first case, Commonality, and then I think it was 66, Chrissy for security. And those cases held for that proposition. Case laws determined either by code, the legislature, or by case law, or oftentimes there will be a code that is codified and interpreted by case law. If you're approached by an insurance company who wants to settle, which they'll do that sometimes, it's usually because they want to get out on the cheap. So if they call you a couple of days after the accident, say, hey, we're going to give you $5,000, that's usually because the case is worth much more, and they will do that sometimes. So if you really don't believe you're injured and it was just fine and you won't be injured and you're good with it, sure, but you can take the settlement. But typically they're offering you much less than if you would go out and get a lawyer. That's why they're offering it to you soon, because they don't want you to go out and get a lawyer, because a lawyer will tell you your rights, and a good lawyer will tell you what they're offering is fair and you don't need me, or you do need me, because we typically work on a percentage basis. In other words, we only eat what we kill. We can settle a case without filing a lawsuit. We take a third. That's typical in California. All attorneys do that. And the retainer says that if you go into court, initiate litigation, it's 40%. That usually involves discovery, which is anywhere from depositions, taking, deposition under oath, which nowadays on Zoom, like right here, or it can be in person, and there can also be a lot of written discovery. There could be medical exams, site inspections, and experts. People typically have to hire medical doctors or liability experts or life care planners or economic analysts, consultants, and that gets expensive too, and you have to depose them. So there's a lot of time, risk, and expense in going to trial. If you do hire a lawyer, make sure that he's actually been to trial. Personally tried probably over 50 jury trials, tons of bench trials, and countless arbitrations, because I've been practicing a long time. It was easier to go to trial back when I was younger, and some attorneys just won't go to trial. They don't have the confidence. They don't, they don't want to work that hard. But a good lawyer will do what it takes to represent their client, and a good lawyer is usually one who will take it to trial if necessary. Now, there are lawyers that can work their cases up so well that the insurance company, they will offer what's fair, but that's not, even if you do everything you're supposed to, insurance companies will do what they want. Why? Well, because they can't. And the only person who's going to tell them otherwise is a jury. And sometimes you may have a good case, but they may think your client's not likable. They may not like a doctor. They may have their mind set up about something, and they just won't pay. Typically, nobody usually feels okay after an accident. They usually feel shocked, or they feel adrenaline. They feel stunned. Sometimes they feel a sense of like just surprise. And a lot of times people will feel that and think they're not injured, because that the adrenaline will mask any injury, or injuries can sometimes not. You're shocked, but then they'll really start setting in hours or days later. So it's always good to get checked out by a doctor, if you've had a significant car accident. Well, like I said, it's all about money. I mean, they'll fix your car if, usually if it's up to 60%, they'll usually pay it. After that, 70-80%, anything above that, they'll usually total it out. And you can either keep salvage or not, but they'll pay for that, and then money is what it is. I mean, you can't turn back the hands of time and say, if you didn't rear-end me, I wouldn't have gone through the doctors and had pain and so on and so forth. And I spent 10 grand and I lost $10,000. But if you were to give me $50,000, that doesn't turn back. There's nothing to turn back the hands of time. Question would be is would you go through all that? Would you know that you're going to go out and get hit by a car, rack up medical bills, be out of work, not be able to surf or do what you love? And if I were to say, hey, I'm going to give you 50 grand, you're going to get smashed by a car driving down to Orange County on the 405, and you're not going to be able to surf, you're not going to be able to, would you take? Because that's the only form of compensation we have in our system of justice in the United States, which is based on the English common law system, which is compensation. Because, again, you can pay your lost wages, and lost wages, even if you take time off from work and you get paid for it, you can still, then you're using up your sick or your vacation time. Under the law, the insurance company should pay for it. Or, if you pay for medical bills, or you incur them, they should pay for those. If your insurance company pays, you can go through your health insurance, but the law changed years ago when the case was called Howell in the Supreme Court. They said that the insurance company is only responsible for what the victim's insurance company pays, health insurance company pays. So that law changed. So it's always best to go to a doctor on a lien, which means that they will settle the case. They will get paid when the case is done. And we typically have doctors, all over the state in all kinds of facilities or disciplines to help people, either treatment or evaluation or radiographic, as we discussed before, for all of those types of things. And then, typically the money goes to the attorney trust account, we pay the doctors, we pay the client, and then ultimately we pay ourselves, whatever our fees are that we've negotiated and any costs out of pocket. For example, lawsuit itself, filing a lawsuit is $435 unless you qualify for a fee waiver. And that, that's just a cost. And then you've got to typically, you can send to a defendant, will they accept service? Sometimes they do, but typically they don't. So you have to go chase them down and get on service. That's another $150. You got to pay sometimes for investigators, small things like police reports, I don't know, $30 or something like that. And medical records, like if you go to UCLA, might be a couple $100 to get the medical reports. Especially if they've been there for a long time, because there could be a lot of documents. If you've been in the hospital for days, you're going to generate a lot of documents. So that's usually how, they'll send you something, you have to release your rights, you get no more. And then the insurance company, once you send the release and sends the check to the attorney, we deposit it in our trust account, let it clear, pay the doctors, pay the client, and pay ourselves. That's how it works. Posting an accident, it doesn't hurt. You're going to get all kinds of responses. You could pretty much rest assured that insurance companies will look into Facebook, Instagram, maybe your Twitter, maybe, whatever, TikTok or Snapchat or whatever. Yeah, I mean, I would always tell people not to, but if they had an accident, thank God I'm alive, but I was, but anything is going to be interpreted a certain way. And this is a really good question, because I've had people go on Facebook and talk about doing all kinds of wonderful athletic activities while they claim they were injured, and that will cost. I've seen it happen a number of times. So it's a very good question. I'm out partying, I'm traveling, I'm doing whatever. And one thing is doing those things, but the worst thing you can do in any lawsuit anywhere is to lie. And the worst guy you can lie to is your lawyer. I've had people come in and say, oh, I never had a prior accident or never had a prior injury. That's easily found out. And then, oh, I had a prior accident. Okay, we can deal with it. But if we're proceeding along the way that we haven't, and we tell that, then, if they catch you like that, it's devastating. And the worst is under oath. When you do what we talked about, discovery, if they're taking your deposition, you are responding under oath. You've taken an oath, by the court reporter who's a notary public, and it's an oath as if you're in a court of law. So, and the same thing with written discovery, you sign a verification that the answers are under oath. And if you say something like, I haven't had another accident, or I haven't had another injury, and they find out, it can be devastating. If you're honest, then we can work with it. Okay, you're entitled to aggravation. You had a bad back surgery 5 years ago. That's okay. You were asymptomatic. That only helps. Unless you don't say it, then it can be devastating. Or they may ask, have you ever been convicted of a felony? And there is a question on the judicial council, the one, the judge's committee wrote out discovery form interrogatories about 35 years ago that everybody has to use. And one of the questions, have you ever been convicted of a felony? They can get your criminal records. If you have, it's better to say, yes, I have, rather than lie about it. The point is, don't lie to anybody, particular lawyer. And if they find out under oath, then, I always say, you lie, you lose. So be honest. I have a lot of experience, obviously, in this many years, and you want a corporate defendant because they have usually big policies, they have procedures where, their drivers have to abide by procedures, and usually they don't. The accident itself is one. They're not emotional about it, and like I said, usually the policies are big, and usually if it's a truck or something, it's going to be a more serious accident with a commercial vehicle. A large vehicle, which typically are commercial, and we've had a number of truck cases. We have a death case now involving a truck that jackknifed on the 395, or commercial, like if we're talking about a slip and fall or negligence. Any restaurant is going to have a commercial policy. Any grocery store, any cafe, any yoga studio, any place of business is going to have a commercial policy. And Uber, yeah, they've increased their limits. They have $1 million now. They used to have 15. They tried to not get insurance, and then that got changed, so they all are well insured now. Or Lyft is the same thing, or any of those car companies out there have to now have a significant policy. And again, they would rather see it go away. So my experience is they're pretty good about paying. The relationship, like if it's your parents, your siblings, your kids, stepkids or step parents, if there's economic support, obviously a spouse. So it has to be a family member, close family member, as I discussed. Now, the first thing would be, again, it's the same thing about economics. If a father was making $300,000 a year and they have 3 kids, and they leave a wife and 3 kids, 300,000 in 10 years, they would have made, $3 million, but there's also less personal consumption, and there's inflation, and there's raises, and there's all kinds of things considered. Again, important to figure out how much the insurance policy is, because your commercial policy will usually have $5 or $10 million. Most of the limits you see, like if it's a lease vehicle, you're required to have $100,000. So most of the time it's $100,000, 100, 300. That's what I see most of the time. But you'll see 15, you'll see 25. But if you have a death case, the one we have with the truck, there's unlimited insurance, because we have one of the biggest trailer companies, in the world, and the tractor company had limited insurance, but then there's an intermediary. So a good lawyer will find out different defendants and avenues of insurance. So there's the economic damages if, they were providing for you. But the bigger thing is the loss of love, society, and comfort. If it's somebody that your father that you rely on, and he was wise, you love time with him. Well, there's no real value that you can put on that. So it's a subjective value. And that's one of the hard things about, if I say, I'm going to lose my son, there's no amount of money in the world, none, that would pay me for that. None. I don't care if you give me hundreds of millions. I don't care. But if it happens, then that's the only way to compensate. And I think, that's showing you something. It doesn't take away your pain. It may make your life a little easier, where you lose your motivation or something like that. Any child under 18, a settlement that's under $5,000 has to be put in a blocked account until the minor turns 18, because you don't want to give an 8-year-old $100,000. What are they going to do with it? So you put it in a blocked account. It can be in the form of annuity, and then when that kid turns 18, hopefully you give them $100,000, and when they're 18, it's 150, or they can do it in the form of annuity, which I'm sure you're familiar with. So that, that's how typically they're apportioned. I think we do have survival benefits, but it's just more how people are paid, and that is up to how it's worked out. Usually it's worked out in a certain way. Motorcycles obviously are, usually if you're injured, you're badly injured. You have no protection. It's usually a fracture. It's usually, it could be paralysis. It could be death. It's, but it usually involves broken bones or serious injuries. And the insurance company can't say, we shouldn't be riding a motorcycle. Will a jury do that? Well, they might, because that's a human being. But the law doesn't punish you if you're, riding a motorcycle properly and have a helmet on. But typically, they really don't punish you for riding a motorcycle. And the injuries are bigger, so the settlements are typically bigger. When I get a major accident, people go, well, you can go to the best lawyer in the world, you cannot get, and I always tell people that it doesn't matter, it's how much insurance is out there. And if the defendant doesn't have a lot of insurance, but they have assets, well, you could pursue that, but it's, people can hide assets or sell things or put them offshore. There's all kinds of loopholes. to make it hard to get a judgment. It's typically soft tissue, which, you have your spine, your cervical, your thoracic, and your lumbar spine. And if you have a neck injury, it's a cervical injury, and you have, your C6-7, C5-6, C4-5, C3-4, C2, and C1, and all of those. That's the C is what cervical, different levels of your spinal cord, which is, how it looks. The cord is there are little levels, and they're connected with nerves, and then there's something called nucleus pulsus within there. And if you suffer a sprain or a trauma to your spine, that can make the disc, you have a natural curving to your lordotic spine, and that can straighten out. And you can also bulge a disc or herniate a disc, which can be shown on x-ray, but more on MRI, and it will show like the material, which is the nucleus pulsus, bursting out of the and hitting a nerve. And that's like a jelly donut, where that's what people usually use as an example. But then if you hit a nerve like your C6-7, you should have that controls, the nerve goes down your left arm and all the way down to your left pinky. And if you have radiculopathy, meaning any type of radiating pain, that usually means that it's pushing on the nerve, and they may have to either do it by therapy, or shots, epidural, or there's pain management, but that usually doesn't relieve the problem. And ultimately, is you have to do a discectomy or cervical fusion. And the same thing goes on with your thoracic, less so, but lumbar. Sciatica is your C5, C4-5, C5-6. That's can cause the same thing, an extruded nucleus pulsus, so you can get pressure on your nerve, and it has to be corrected by doing some kind of lumbar fusion or some type of a surgery, or if you can treat it, make it go away. But people, for example, I'm 60 years old, I'm active, we all have degenerative, if you're older, your discs aren't like you were when you're younger. You're going to have some protrusion or bulges. I personally don't have any pain. I'm just lucky at my age not to have any. Maybe slight back pain every once in a while, but nothing acute. Just sometimes it'll come on if I do something, where I jar it, or if I, if I sit too long or whatever. But it's never that bad. It usually goes away. But there are people that will have constant pain, and they can't sit, they can't drive, they get headaches, they can't concentrate, they're in a bad mood, that all of those things can be as a result of an injury. But the more severe, the longer, and the more intense the pain should be, and accordingly, the more the treatment should be, and the more the settlement can be, again, all within the parameters of the policy.
Thanks for listening to the Los Angeles Injury Attorney Podcast. Whether your case is a personal injury lawsuit, an employment case, or insurance bad faith litigation, Olan Law will do everything legally necessary to get you the compensation you deserve. There are no upfront fees, and if Olan Law doesn't win your case, you pay nothing. You can contact us by calling 310-566-0010, or by using the handy contact form on our website, olinlaw.com, where you will find a wealth of information about our practice areas and some of our more notable verdicts and settlements. If you found this podcast useful, please follow, rate, and review. That really helps us grow. Thanks for listening.